been here throughout the course of the trial, and everyone has conducted themselves appropriately. I am going to render a verdict, so if you don't feel that you are going to be able to handle that, I would ask for you to step out in the courtroom while we do that. So, thank you all for your time and your patience. I have carefully considered all the testimony, the exhibits that have been entered into evidence, the arguments of counsel, the applicable law, and these are my findings of fact and my conclusions of law. First, it's important to understand what my role is. Ordinarily, this would be a jury trial. In the jury trial, the court's role is limited solely to presiding over the trial and to instruct the members of the jury on the issues of the law. In this particular trial, probably because of all of the extra stuff, which is a technical legal term, that came along with this case, my role is to be both the arbiter of the law and the interpreter of the facts. Many of the issues that were brought up in the trial are only partially relevant to some of the issues of the case. So as such, my job is to limit my view of that evidence only to the evidence which is admissible, and then only for the purpose for what is admissible. So in this role, what are the rules and what rules govern my analysis? Fortunately, the Supreme Court gives us some rules, and they would be the rules that I would provide to jurors if they were here in court. In this case, the defendant has entered a plea of not guilty. So I must presume or believe he is innocent. This presumption stays with him as to each material allegation in the information through each stage of the trial, unless and until it's been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and that the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. What is reasonable doubt? Reasonable doubt must, whenever the words reasonable doubt are used, I must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such doubt must not influence me to return a verdict of not guilty if I have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proven beyond every reasonable doubt, and I must find the defendant not guilty because the doubt is reasonable. It is the evidence introduced into this trial, and to it alone, that I am to look for that proof. A reasonable doubt as to the guilt of a defendant may arise from the evidence, the conflict in the evidence, or the lack of evidence. What rules do I have, or what rules do jurors have for deliberations? The Supreme Court gives us 7. In this case, there are 3 which I find to be primarily instructive to guide my analysis. The case must be decided only upon the evidence that I've heard from the testimony of the witnesses and seen in the form of the exhibits and evidence and the jury instructions. The case must not be decided for or against anyone because I feel sorry for anyone or am angry at anyone. My verdict should not be influenced by feelings of prejudice, bias, or sympathy. My verdict must be based on the evidence and on the law contained in the jury instructions. So for me, this case is not a case about Mr. Goldberg and Ms. Schwitzky's relationship. I'm not here to pass judgment over whether or not it was a good idea or a bad idea for them to be together. This case is not a case about whether or not the defendant was affluent, what his family history is from. As the state correctly pointed out in their closing argument, anyone can do anything. Good people can make bad decisions, and if it's been proven, they need to be held accountable. Ms. Schwitzky's job is not a consideration for me in my deliberation. It's simply not relevant. It is relevant to the issue of bias and credibility. So let's talk about that. Let's talk about what I look at when I'm deciding and weighing the evidence, which is what I have to ultimately do with the witnesses that were called to testify. It's up to me to decide what evidence is reliable. To do that, I should use my common sense in deciding what is the best evidence, what evidence should not be relied upon in considering my verdict. I may find some evidence reliable, or less reliable, or not reliable than other evidence. To consider that, I have to consider how the witnesses acted when they testified, as well as what they said. The things I need to consider are, 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? In this case, this comes in the form of different views from different individuals located in different places, under different levels of intoxication. Did the witness seem to have an accurate memory? Were they impeached with their prior statements? Did they indicate that they did not have a recollection of certain things when they were asked questions by one side versus by the other side? Was the witness honest and straightforward when answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? That is ultimately where my analysis primarily focuses. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that's inconsistent with the testimony that they gave in court? So these are the rules, and this is the framework that I have to use when I'm analyzing what my verdict should be. I then turn to the information. The information is the charging document. It's not proof of anything, but it is the formal charges that the state has filed against Mr. Goldberg. It's a 3-count information. Count 1 accuses Mr. Goldberg of committing the crime of attempted second-degree murder. Count 2 accuses Mr. Goldberg of the crime of domestic battery by strangulation. Count 3 accuses him of the crime of battery. To prove, with respect to attempted second-degree murder, to prove the crime of attempted second-degree murder, the state must prove the following elements beyond a reasonable doubt. First, Cole Goldberg intentionally committed an act which would have resulted in the death of Carolyn Schwitzky, except that someone either prevented him from killing her or he failed to do so. And 2, the act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is imminently dangerous to another and demonstrating a depraved mind without regard for human life if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. To prove the crime of domestic battery by strangulation, the state must prove the following 3 elements beyond a reasonable doubt. First, the defendant knowingly and intentionally impeded the normal breathing of Ms. Schwitzky against her will by applying pressure on the throat or neck or by blocking the nose or mouth of Ms. Schwitzky. 2, in so doing, the defendant created a risk of great bodily harm to Ms. Schwitzky. And 3, at the time, the defendant was in a dating relationship with Ms. Schwitzky. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. Count 3 is the crime of battery. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. 1, the defendant intentionally touched or struck Ms. Schwitzky against her will. So I then turn to the facts of the case as I see them. The state is correct that when a fact finder, either a jury or in this case myself, is confronted with conflicting views of the evidence, I must attempt to resolve those conflicts if I can before simply deciding that there is reasonable doubt. In any situation with multiple witnesses from multiple angles, there will be conflicts. The question for the court, the question for the fact finder is, are those conflicts such conflicts that it creates in the mind a reasonable doubt? A reasonable doubt can arise as to any of the elements of the crime. So I'll turn to my analysis of each count. With respect to simple battery, there was no bill of particulars that was requested by the defense or filed by the state. So I will look at 3 potential theories of prosecution for simple battery. First, the throwing of the seltzer bottle at Ms. Schwitzky. Ms. Schwitzky testified that Mr. Goldberg threw the seltzer bottle at her. It hit her in the face. It knocked her down. She felt violated, but she did not believe that he did it intentionally. The defendant denied that it happened, denied that it hit her. There were no independent witnesses to this event. There were no injuries that were observed to Ms. Schwitzky's face. Based on my review of the evidence and the photographs and evidence, I did not observe any injuries consistent with being struck in the face by a seltzer bottle. So I have a reasonable doubt based on that conflict of evidence, if that is the theory of prosecution. The second theory of prosecution for simple battery was the allegation that Mr. Goldberg grabbed her and wrestled her to the ground on the boat. Ms. Schwitzky, Mr. Goldberg denied that he grabbed her against her will. He indicated that he was trying to comfort her or prevent her from jumping off of the boat. Ms. Schwitzky testified that he grabbed her, wrestled her to the ground, that he bit her, and scratched her with his nails. There were no injuries consistent with bite marks that I was able to observe from any of the photographs that were introduced into evidence. There were no injuries visible on Ms. Schwitzky consistent with scratch marks from nails. Ms. Schwitzky alleged at one point either he digitally penetrated her or he roughly grabbed her in her private area. None of the witnesses testified that they saw this. None of the witnesses reacted to this. If there was documentation of these injuries, it was not provided to the court. None of the independent witnesses on the boat indicated that they observed him holding her roughly in that manner. None of them indicated that they heard her screaming at the top of her lungs. So I do find that there is a conflict in the evidence such that there is a reasonable doubt as to this theory of prosecution. The final potential theory of prosecution was that after that incident took place, the wrestling on the ground, that Mr. Goldberg threw her off of the boat. Ms. Schwitzky clearly testified several times on both direct examination and cross-examination that Mr. Goldberg threw her off the boat. Mr. Goldberg denied it. Mr. Whiting, who was on the other boat, not the trap check boat, he explicitly denied that she was thrown off of the boat, and he testified on both direct and cross-examination that she jumped off of the boat. Mr. Bullen also testified that he observed her jump off the boat. On this record, I cannot find that this theory of prosecution took place. Therefore, the verdict of the court as to count 3, simple battery, must be not guilty. With respect to attempted second-degree murder, attempted second-degree murder involves an act which would have resulted in death. Imminently dangerous, with a depraved mind without regard for human life. The classical example of second-degree murder is an individual with a firearm firing gunshots into a crowd without any specific intent to harm anyone. But that act is so imminently dangerous to human life and shows a depraved indifference that they would be guilty of attempted second-degree murder, even without an intent to kill. I have only been able to find in my research a single case regarding attempted drowning. That case is Mook versus State. 293 Southern 3rd 32. It's a 4th District Court of Appeals case in 2020, binding on this court. The facts of Mook are only briefly stated because it is a collateral attack to a conviction. But in that case, the 4th District Court of Appeals upheld a conviction for attempted second-degree murder when the defendant threw his girlfriend off of a boat, then followed her into the water and pushed her underwater at least twice. So what facts do I have in this case? There are several different facts that I find to be germane to the court's analysis as to imminently dangerous to another, demonstrating a depraved mind without regard for human life. First is the time that Ms. Schwitzky was submerged under the water. Mr. Paris, who was the individual that provided her aid when she was under the water, testified that she was under the water for approximately 4 seconds. Rachel Tarachek testified that she was under the water for approximately 10 to 15 seconds. I believe it's Sherilyn Tarachek, that the other Ms. Tarachek, Mr. Paris's former wife, indicated that Ms. Schwitzky was underwater, quote, longer than normal, but she could not give a specific time. Alex Tarachek, the owner of the boat, testified she was under the water 5, 6, maybe 10 seconds. Mr. Bowen was not able to provide time that she was submerged under the water. Mr. Whiting was not able to provide time that she was submerged under the water. Ms. Schwitzky testified that she was under the water 30, 40, or 50 seconds. The second thing for me to consider is whether or not there was a struggle, whether or not Mr. Goldberg attempted again to re-submerge her once she came up for air. Mr. Paris indicated that there was no struggle, that he simply helped her with his hand lifted her up out of the water. She got on the boat. No one said that Mr. Goldberg went after her a second time, other than Mr. Alex Krabchek. Mr. Alex Krabchek clearly testified that the defendant again attempted to submerge her under the water. Mr. Bullen specifically said that Mr. Goldberg did not go back after her. Ms. Schwitzky testified that once she was saved by Mr. Paris, she had to be thrown back in the boat because she was not able to get back in the boat. Next is the manner in which she was submerged. Mr. Paris, Ms. Rachel Trabchik, Mr. Alex Trabchik, Mr. Whiting, and Mr. Bullard all testified to different manners in which they observed Ms. Schwitzky being submerged under the water. Mr. Paris demonstrated 2 hands on her shoulders, not clasped around her throat, but in the throat area. Ms. Rachel Trabchik's demonstration was similar, with the hands closer together. Mr. Alex Trabchik's demonstration was closer together. Mr. Whiting, I believe, testified that there was 1 hand placed on her head. Mr. Bullard also testified that he was not able to observe it. Ms. Schwitzky testified that Mr. Goldberg grabbed her and she believed that she was being attacked like by a shark, that she was thrown around like a rag doll, back and forth. There were no injuries that were consistent with such a violent manner in which that she would be submerged. So based on this conflict in the testimony, the court has no choice but to find a reasonable doubt as to whether or not a person of ordinary judgment would know that their acts are reasonably certain to kill or do serious bodily injury to another, or that the act is done from ill will, hatred, spite, or evil intent, or is of such nature that the act itself indicates an indifference to human life. Additionally, I would note that it wasn't until Mr. Goldberg's cross-examination that it was discovered that Mr. Goldberg had reported on the day of the incident that he was having difficulty swimming to Fish and Wildlife approximately 20 minutes after they began their investigation. So because I do not find that there is proof of each element beyond reasonable doubt, the verdict as to how one must be not guilty. The final element for me to prepare, the final charge for me to consider is domestic battery by strangulation. There are 2 theories by which the state can pursue conviction for domestic battery by strangulation. First, that the defendant knowingly and intentionally impeded the normal breathing of the victim against her will by applying pressure on the throat or neck of Ms. Schwitzky. I do not find that anyone testified that that was what occurred in this place, that he physically choked her and there were no injuries consistent with her being choked. The second and more likely theory of prosecution is that Mr. Goldberg intentionally and knowingly impeded her breathing by blocking her nose or mouth with water, and in so doing created a risk of great bodily harm. I previously discussed the conflict that I have with respect to the manner in which she was submerged under the water, which gives the court concern with respect to the creation of a risk of great bodily harm and the knowing and intentional impeding of her breathing. I don't find, based on the record, that the evidence supports any of these elements beyond a reasonable doubt. Thus, the verdict must be not guilty. So, accordingly, for these reasons, I do adjudge Mr. Goldberg to be not guilty. I'd ask the court to provide me an order adjudicating not guilty.
Can you step away from her a little bit? We would all appreciate that, actually. Okay.